Mr. Glenn,
Good.
good morning.
How are you?
I'm all right. Mr. Lemons is in state custody.
Yes.
So what we need to do is line up a Zoom. Do you need any assistance in connecting with him?
I just have my phone actually on my computer.
Oh, we don't have him. We didn't know that he was in state custody, so he is not with us today. But I only learned today, other people may have known, you may have known, that he wasn't at the county jail. He actually had been sent to GDC custody. And so what we need to do, if you think this is a resolvable situation, which I think it is, but not my call, that's yours and Mr. Lemons's. But if it is, then we'll patch him in virtually from, I think he'll be at Jackson for a little while, and just resolve this so it's not hanging over his head. Do you have a way of contacting him, or do you need a connection with GDC to do that?
Probably a connection with GDC and also to, if I could have a moment to conference with the state just to make sure we're on the same page and everything.
Okay.
So that'd be good.
Well, what I'm going to do is send an email to you. I'll copy Ms. Davis. That email to you is going to have the contact information for GDC, how you could line up a teleconference with Mr. Lemons that is privileged, so you guys would speak privately. And we will work, to set this down for a plea date in a few weeks. And it'll just need to be, you're welcome to be here in person, but your client's going to be virtual. So if it's easier for you to Zoom in from your office or wherever, that's fine with me. All right? All right.
All right, thanks. I'll go ahead. So I should just, since we don't come to resolve it today, I can just go ahead and get the comments from Mr. Dunn.
Yep.
And I'll have notice for you.
Exactly. So you are free to go now. You'll have Ms. Davis's contact info through the email that I send out that gives you the GDC teleconferencing info. All right?
Thank you.
Sure.
Back to the same.
Same. All right, Mr. Kendall,
Yes, Judge.
want to bring your client on up? Ms. Davis, are you ready?
Yes, Judge, I'm ready.
All right. Well, let's get on the record in position 4, State versus Antoine Broughton. Am I pronouncing your name correctly?
Broughton.
Say it again.
Broughton.
Broughton.
Is that not what I said?
It's like you said, Broughton.
Okay. I'm trying to say it that way. Anyway, we've got you here along with your lawyer, Mr. Kendall, Ms. Davis for the state. It's 24 SC 005 020. And Mr. Broughton, you are prepared to enter a plea?
Yes, sir.
Okay. Ms. Davis is going to put you under oath, ask you very similar questions to what you just heard her asking Ms. Walker. And I will hear from her. I'll hear from Mr. Kendall and you if there's anything you want to add, and we'll see where we go. All right. Let's get started.
Please raise your right hand. Do you swear or affirm that the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name for the record.
Antoine Broughton.
Can you spell your first name and pause and then spell your last name?
ANTOINE BROUGHTON.
Are you at this time under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
44, 10th grade,
What high school did you attend?
South Atlanta.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with one count of burglary?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Mr. Kendall, about all the facts and circumstances known to you regarding the charges in this indictment and any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes.
Mr. Kendall, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
Yes, we do.
Mr. Broughton, do you remember having been arrested on these charges?
Yes, ma'am.
The state is unaware, Your Honor, of any outstanding warrants related to this matter. Attorney Kendall, are you aware of any outstanding warrants?
No outstanding warrants.
Mr. Broughton, has your attorney advised you the minimum and maximum sentence for the charge to which you're pleading to today?
Yes, ma'am.
Okay, the maximum sentence would be 5 years.
Hmm.
Okay. Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has a right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
Mr. Broughton, today, if I sentence you to more than what Mr. Kendall asks for, you're able to withdraw your plea. That's what's significant about the final plea date. So I'm making numbers up, but if Mr. Kendall says, Judge, it should be 2 years probation, and I say, I think 4 years probation, you and Mr. Kendall will have a chance to talk. And if you are dissatisfied with that sentence and would rather go to trial, no questions asked, you just say, that's really not what I'm interested in doing. And then we just keep your case on the trial calendar. I'm not saying that because I think I'm going to disagree. I haven't heard anything about you or the recommendation, but I want you to know that you'll have that opportunity to ponder if my sentence is different from what Mr. Kendall asks for. Okay?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? That's true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which can carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand you have only 4 years from today for this felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 24 SC 005020 to the count of burglary in the second degree?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Judge, we believe that at trial, the evidence would show on January 17, 2023, officers with the Atlanta Police Department were dispatched to 786 Cleveland Avenue in Atlanta, Georgia, in Fulton County to an extra space storage facility in regards to a burglary that occurred on site. They were actually called out there by a manager after noticing a unit had been broken into. Upon arrival, officers met with the owner of that unit, Mr. Mikan Diallo, and he indicated that someone broke into a storage unit and stole about 60 pair of Nike shoes. The surveillance footage revealed there were 2 males who entered the facility, one of those males being the defendant. That the defendant did use his PIN to enter the extra space storage facility because he also had a unit there, and then was captured on the surveillance footage removing boxes, Nike boxes of shoes, and exiting the building. The manager of the facility also recognized the defendant, and that's how they were able to identify the defendant as a person being involved in that burglary. We are recommending to the court that the defendant do 5 years of probation, that we're reserving restitution. We did try to attempt to reach out to the victim, but we're not able to. And so at this time, we don't have an amount of the value for the sneakers. So we're asking to reserve restitution, that Mr. Broughton complete an anti-theft course, that he obtain his GED if he does not already have it, complete 60 hours community service, stay away from the incident location, meaning for him to, I guess, complete the term of his, if he's still renting at the extra space facility, but to stay away from that facility, and then of course the victim. And that is it.
That's it? Okay, thank you.
Well, that took a turn. We sat in on the plea hearing for Antoine Broughton today, and I've got to say it was one of those proceedings where everything looked routine on the surface but had just enough detail underneath to raise an eyebrow or two. First off, Judge Washington once again brought his signature approach: steady, fair, and personable. From pronunciation checks to procedural clarity, he kept the tone firm but respectful throughout, giving Mr. Broughton the space to speak and ensuring the process was understood at every step. There were no theatrics from the bench, just steady guidance and a clear sense that everyone's time, including the defendant's, was being treated with seriousness. Mr. Broughton himself, 44 years old, soft-spoken, respectful, entered a guilty plea to burglary in the second degree. He responded with clear "yes, ma'ams" and "yes, sirs" throughout the colloquy, showing no signs of confusion or reluctance. While he only completed 10th grade, he affirmed his ability to read and understand English and didn't seem under the influence or impaired in any way. His body language and tone were subdued, more resigned than defiant, and when he acknowledged the factual basis for the plea, he did so without hesitation. No outbursts, no excuses, just a quiet admission of guilt. The charge itself came from a 2023 break-in at an extra space storage facility. The details? About 60 pairs of Nike sneakers were reported stolen. And here's the kicker: Mr. Broughton allegedly used his own personal access code to enter the facility. That bit certainly caught my attention. Using your own PIN in a place with surveillance cameras? Let's just say it didn't take a team of detectives to connect those dots. To the state's credit, the presentation of the case was matter of fact. Miss Davis laid it out cleanly. Surveillance footage, access logs, and even a facility manager who personally recognized Broughton. It's not flashy evidence, but it's solid, and it told a consistent story. As for the sentence, this was a negotiated plea, so the state recommended 5 years probation, no jail time, as well as several conditions: an anti-theft course, a GED requirement if he doesn't already have one, 60 hours of community service, and a stay-away order from the storage facility and the victim. Notably, the judge agreed to reserve restitution since the state couldn't get an exact value for the missing sneakers. Fair enough, can't put a dollar amount on what you don't have a record for. Overall, this hearing ran smoothly, no surprises from counsel Mr. Kendall represented his client with quiet confidence, waiving the reading of the indictment and confirming there were no outstanding warrants. And while Mr. Broughton didn't say much beyond what was required, he met the moment with the seriousness it deserved. The courtroom vibe was low-key but professional, a clear sense that everyone was just trying to bring closure to a straightforward case. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.